What is the prenup infidelity clause? An infidelity clause in a prenuptial agreement can sound powerful, but New York courts may not always enforce it. In New York, this kind of clause usually tries to impose financial consequences if one spouse commits adultery during the marriage. Couples often consider it when significant assets, business interests, or future support obligations are involved. Under Domestic Relations Law Section 236, b-3, prenuptial agreements can address property division, maintenance, and other terms of the marriage relationship. To be enforceable, the agreement must be in writing, signed by both parties, and acknowledged or proven in the manner required for a deed. New York courts generally enforce properly executed prenups unless someone proves unconscionability, fraud, duress, overreaching, or similar inequitable conduct. An infidelity clause is sometimes called a no-cheating clause or fidelity clause. It may require the spouse who violated the agreement to pay a set amount, give up certain assets, or lose entitlement to spousal support. These clauses can vary widely because some define infidelity broadly while others limit it to specific physical acts. That definition matters because it affects what evidence would be needed to prove a violation. A well-drafted clause should clearly define the conduct at issue and state the proof standard that applies. Many agreements use a preponderance of the evidence standard, meaning it is more likely than not that infidelity occurred. Financial penalties should also be reasonable because extreme penalties are more likely to be challenged as unconscionable. Confidentiality terms may also be included to limit the use of sensitive evidence and protect private information. The biggest legal issue is that New York is a no-fault divorce state under Domestic Relations Law Section 177. Because divorce does not require proof of wrongdoing, courts may be skeptical of contract terms that penalize marital conduct like adultery. There is no bright-line appellate rule saying all infidelity clauses are automatically unenforceable in New York. Still, enforcement remains uncertain and courts may closely scrutinize whether the clause conflicts with public policy. Judges may also consider whether the clause encourages litigation over highly personal conduct that no-fault divorce law treats as legally irrelevant to ending the marriage. Proof can be another major obstacle because adultery claims are fact-intensive and may require corroborating or circumstantial evidence. If the penalty is grossly one-sided or strips one spouse of too much, a court may void that provision. The fairness of the overall agreement matters too, especially whether both parties had adequate time for review and independent legal counsel. An unfair clause can also create risk for the broader agreement if it is used as evidence of overreaching. In divorce proceedings, infidelity is not a standard factor for determining spousal support under New York law. That means an infidelity clause does not automatically change support or asset outcomes unless a court chooses to enforce it. A Manhattan lawyer or attorney can help determine whether such a clause makes sense, while another lawyer or attorney can also help draft terms that are clear, proportional, and more likely to hold up under scrutiny. For guidance tailored to your situation, the law office of Richard Roman Shum, Esq. is a law firm that can evaluate these issues, and this law firm can be reached at 646-259-3416 at 20 Clinton Street, FRNT 5D, New York, New York, 10002, United States.